Now, I think most would agree that constitutional problems and pitfalls in financial regulation are not unique to this area of law, of policy making, but they do seem to take on a different and perhaps more worrisome cast in this area of the law. And I think we'll hear more this afternoon about why that might be. Is it the prevalence of agency independence in this space? Is it the tendency of some financial regulators to prefer case-by-case adjudication over clear ex-ante rules? Or is it simply that financial regulators are still grappling with the implementation of an ambitious new regulatory regime? Fortunately, we have an accomplished panel to shed light on those issues. Beginning to my immediate right, we have Professor Geoffrey Miller, who teaches at NYU Law School and leads the school's Center for Financial Institutions. Next is Ambassador Boyden Gray, the founding partner of Boyden Gray and Associates, a law firm that incidentally filed the original constitutional challenge to the CFPB. We have Professor Peter CONTI-BROWN, who teaches at the University of Pennsylvania's Wharton School, President-elect's alma mater. And of course, Professor NEOMI Rao, our host today, and a professor of administrative and constitutional law here at the Scalia School of Law. I'll now turn to our panelists, who will kick this off with about 10 minutes of remarks, opening remarks each, followed by what we hope will be a lively Q&A.
Okay. I guess I'm starting. I would like to say I could speak as fast as Richard Epstein, but I can't. So I'll go at my own pace. Been asked to talk about a paper I wrote. The paper is really a broad discussion of the regulatory state and its discontents. What does this have to do with financial regulation? Well, Brian really mentioned it. A lot of the problems that have come up in the regulatory state have arisen in a most poignant way in the area of financial regulation. And it's also possible that the mitigation of those problems will arise out of financial regulation as well. So financial regulation might be the source of some of the problems, might also be the path towards a solution. So that's the tie-in to the topic of this event. The basic premise of my paper is that we've moved from a judicial to an administrative style of regulation. So if you go back a long time now, but let's say 100 years, if a government wanted to regulate, it was a litigant in court. They had to file a case, they had to prove their case under ordinary standards of proof. The judges were the ones who would establish the law, determine the law, administer the law. All of that has changed fundamentally in the years since. We are now in an environment of administrative regulation where judges have been really relegated to the margins. So we talked about the Chevron doctrine. Administrative agencies basically determine the law. What about the facts? Well, judges have some impact on the facts, but there's very, very deferential standards of judicial review, arbitrary and capricious under the Administrative Procedures Act. So judges basically play a minimal role. We also have an environment where we have a lot of enforcement proceedings and administration through enforcement proceedings, and the consent decrees that come out of this, or the deferred prosecution agreements or guilty pleas, are presented to judges, but the judge's job there is basically to be a rubber stamp in many cases. The courts are relegated to the position of being juridical Bob Cratchits, who sit around and basically process papers and have no substantive input on the results. So this process of progressive minimization of the judicial function and administration has been going on a long time, and until recently at least has only been accelerating. I view this as a concern, and the gist of my paper is that judges ought to step up to the plate and play a more active role in administration than they've played in the past. Now that said, obviously judges have limitations by virtue of the fact they are judges. They don't have staffs, they don't have expertise, they're busy. And obviously administrative agencies perform important tasks, so they can't be disabled from serving the public interest. So we can't have an unrealistic sense of what judges can do, but we can have some sense that judges can do better than they've been doing. Why have judges ceded this authority to administrators? A lot of reasons. Part of it is judges value their prestige, and they want to have a small number of judges. If judges were going to be the administrators of the administrative state, you'd have to have many thousands more judges. That's not going to work, so their role has to be relatively minimal. I feel that the judges have, to some extent, however, boxed themselves into a corner that they didn't anticipate and don't like, because many judges today feel unduly constrained by the doctrines which they themselves have created, but now kind of bind them in a way that they didn't anticipate and now don't like. We're seeing these days the beginning of what I call green shoots. A green shoot is an expression by a judge of dissatisfaction with the limited role that they've been given in administration. And sometimes these green shoots seem to be growing larger. The PHH case is an example of, I would say, more than a green shoot. It's something that is a significant decision by a significant court that is rather far-reaching in its implications. So the part of the thesis is that judges are beginning to retake some of the territory which they've ceded to administrative agencies. The question arises, how much will they retake? Will they be able to successfully do it? Will this process continue? And the jury is out on that question. Where do you see green shoots? Well, you see green shoots in areas, for example, some judges have begun to be a little bit more vigorous about Chevron deference and this policy of basically ceding the territory to administrators, judicial abdication of the power to interpret the law. Some judges have expressed concern about that, and even the Chief Justice of the United States has, in a dissenting opinion, expressed the view that the administrative state has gone too far in this area and something needs to be done. Now, what needs to be done, he didn't say. My view is that some of the justices of the Supreme Court are beginning to change their agenda, and that the agenda that they're setting up includes in part an attempt to establish a little bit more effective judicial control of administration. We haven't seen that happen yet, but we now have, the new president has an opportunity to appoint a new justice of the court. Judge Garland, who had been named as a justice nominee, would not have been very much in favor, I think, of judges playing a more active role in this area. Whoever the new justice is, who will be, may have a different view on that. So it's possible that these green shoots will evolve into a more active form of judicial scrutiny. There's Judge Gleason of the Federal District Court in Brooklyn, rather famously, although he was quoting someone, but said judges are not potted plants. And this was in the context of a deferred prosecution agreement which had been given to him by the prosecutors, and he was told to sign it, basically. Here it is, sign it. And he didn't like that. And he said, I'm not a potted plant. I'm not just going to sign. What happened to the judicial role if this is what I've been asked to do? So these kinds of expression by judges are perhaps indicative of what can happen in the future. So I want to just very briefly mention some of the ideas that you can see coming out of these green shoot opinions. So I'm going to get to that part. So what can we do? There's a couple of things judges might think about doing. One of them that concerns many, including me, is the very serious erosion of the attorney-client privilege that we see in administrative cases. The view of the Department of Justice, if you hear them talk, is, well, we aren't trying to restrict the attorney-client privilege. We respect the attorney-client privilege. We aren't trying to do anything to diminish it. This, in my opinion, is completely untrue. The Department of Justice, especially the prosecutors, have attempted to erode the attorney-client privilege to being virtually non-existent. How do they do this? Well, they say the privilege relates to communications between a client and an attorney pertinent to obtaining legal advice. It doesn't pertain to facts. Well, anytime you have an organization that's conducted an internal investigation into some misconduct, they get facts. And the facts now the government wants. And they say that's not privilege because that's a fact. Well, that means that any fact you find, even if it's in a investigation conducted under the auspices of and by an attorney, where the communications with the attorney are privileged, the facts are not, and that very seriously undermines the privilege. So perhaps this is one area where we could see some judicial clarification. Administrative enforcement, so much of administrative enforcement is non-transparent. We heard this morning about matters requiring attention, or MRAs. Most people outside the financial world have never heard of an MRA, but inside the financial world, we all know what MRAs are. What is an MRA? Well, the comptroller or other bank regulator will come in and raise their eyebrows at you. And if they raise their eyebrows at you, you are going to do what they suggest you ought to do. It requires attention. It's not something that you have to do. But believe me, if you don't do it, the consequences will be unacceptable. So we have this non-transparent form of compulsion that is operating behind the scenes and outside of public scrutiny. Greater transparency in how administrators perform their function would be a good thing. And judges have, to some extent, begun to insist on that by saying that the documents that appear in court, for example, internal investigations or monitors' reports, are things that need to be disclosed to the public. Enhanced substantive review of administrative action. So the MetLife case, Adam talked about that this morning. Here's an example of Judge Collier, who really is acting under existing law, but exercising a perhaps more rigorous degree of scrutiny of what an agency did than judges would have done in the past. So her approach to MetLife could be exemplary of what judges might consider doing more of in the future. Aggressive application of the rule of lenity. So in a criminal case, interpreting criminal statutes, the judges might consider the idea that criminal statutes should be interpreted with a view towards lenity and not with a view towards being punitive. Deferred prosecution agreements and non-prosecution agreements. Non-prosecution agreements we really can't do much about because they're not presented to the court. Deferred prosecution agreements are presented to the court, and judges can and should exercise a degree of substantive scrutiny in this area. They can't do very much. They do need to defer very highly to the prosecutors, but they can't do more than they have done. What about civil settlements, civil administrative settlements? Well, civil settlements are presented to the judge in the same rubber stamp way that deferred prosecution agreements are, and they often contain statements that the defendant neither admits nor denies any particular conduct. And there are reasons for this, to avoid the collateral consequences of a conviction or of a civil penalty or finding of civil liability. But the judge can also take a greater role here. I'm going to finish up with a mention of an important case from a long time ago, Ex parte Young, that people have forgotten about largely. But Ex parte Young was a case, Richard knows about it. This is a case where a railroad was hit with a gigantic fine, and the fine was so great and was accumulating so rapidly that the railroad, in the court's view, had no choice but to capitulate to what the government was doing. And that effectively precluded the railroad from getting any judicial review. So the idea that the threat of massive sanctions could prevent a regulated party from having realistic access to the court, and that there's a due process right to realistic access to the court, has been largely forgotten, but I think that would be something worth reviving. And the PHH case, while it did not go off on that specific grounds, really does sort of sound in that idea that we really need to have effective judicial review. And if to get effective judicial review, you need to take an appeal within the agency where you risk the director of the agency raising your fine from $6 million to $109 million, well, who's going to take that risk of facing a 1,700% increase in the fine as your price of getting judicial review? This arguably was a violation of the due process rights of the company to have an effective route to judicial review without having to go through this gauntlet of a director who could punish you for having the temerity to do that. So that's where I'll stop, Ron, but I'm happy to talk about any of these ideas during the Q&A.
Ambassador Gray?
So, to pick up where this wonderful paper leaves off, I do think that problem is that the administrative state, not just in financial services, has reached or passed maybe the tipping point where the regulators have so much power they can block you from effectively seeking judicial review of any kind if they really want to. And that wasn't the way it was 30 years ago or 40 years ago when I first started here, but it certainly is the way it is today. Judicial review is viewed as an act of war against the agency when it wasn't that way before. Now, so what's motivating this? I'm just going to suggest a potential theory for what's motivating, which may help, in unwinding all of this. You look at Dodd-Frank per se, and you see that it doesn't really deal as Peter Wallison has pointed out many times, doesn't deal with the real problems. It doesn't deal with these bad loans, doesn't deal with Fannie Mae, Freddie Mac. It doesn't deal with anything that had anything to do with the collapse. That's a hint that maybe something else was going on. And what was going on was it was an excuse, never let a good crisis go to waste, an excuse to enact a bunch of progressive ideas. The liquidation authority, which was talked about a little bit this morning, is going to be ignored if it ever comes to such a crisis. It's really irrelevant to the discussion. The Volcker Rule didn't have anything to do, or the issues addressed by the Volcker Rule didn't have anything to do with the collapse. Perhaps the biggest product of Dodd-Frank is the Consumer Finance Protection Bureau, and of course, what it's aimed at has nothing to do with any of the reasons for the collapse. And so what do I think is going on? I think we see just a continued effort on the part of the progressives to create an administrative state that ousts all the political branches, the White House, the Congress, and the judiciary from any kind of participation. And that, of course, is going to breed huge businesses, which are easy for them to manipulate since they don't have to call 1,000 banks, they only have to call 6. And this leads to sort of a unpleasant kind of symbiotic relationship between the big institutions of government and of business. I hate to sort of say this in public, but it is true, and it was said in public. But as much as J.P. Morgan fought parts of Dodd-Frank going in, Jamie Dimon does say now, the chairman, that it is his moat. And by that he doesn't mean moat in the eye, he means the moat around his castle, protecting against would-be entrance into his market. And of course, what happened is the big banks became twice or 3 times as big after the fact than they were before. And this, of course, is something I think the progressives really like. The Consumer Finance Protection Bureau to me, reawakened the earliest days of my law practice in Washington back in the early 70s when Ralph Nader proposed a thing called the Consumer Protection Agency, the CPA, which actually came very close to being enacted. It bears a very strong resemblance to the CFPB, and it came very close to being enacted until we were able successfully to point out to the White House, to the Carter administration, that it was to be independent of President Carter. Well, that ended the discussion as soon as he finally fully understood this, and thank God it went away. However, in the climate that we live in now, having an agency that's not only not responsive to the president, but not responsive to the Congress or the courts, basically didn't raise eyebrows in the Congress or the courts yet. The courts are beginning with Judge Kavanaugh to wake up, and I think what's of course happened is that the overreach by these agencies has gone so far that the judiciary has finally woken up to the problems that they're dealing with. But I think it's the progressive ideal that is motivating much of this. And this was, I think, you could say, Adam Smith's worst nightmare. Now, this is not new. Adam Smith feared, he didn't like Edinburgh businessmen very much, but he feared, probably more than anything else, a government that allowed businessmen to capture parts of it for their own private, competition protection purposes. And so he was really terrified of what, and would be today, he would have said, "I told you so, you got to watch out for this." And so I think that's what's happening. And to give you an example of how it has happened, I mean, what's happened from this, what we have is rules from the CFPB which basically have eliminated the use of what I grew up with in a relatively small town of North Carolina, which they called Winston-Salem, which created a couple of major banks, Wachovia, BB&T. Wasn't Hicktown as far as financial services was concerned, but the name of the game was character loans. You made loans based on character far more than checking bunch of boxes. Those are now prohibited. You have to check the boxes. And we know from very serious studies that character loans have a much higher rate of repayment than a cookie cutter box checking loans. And of course, we have a total, not total, but rapidly declining role of community banks. As the big banks get bigger and bigger and bigger, community banks have gotten fewer and fewer and fewer, and they don't make mortgage loans anymore. Our client doesn't make mortgage loans anymore, can't handle the regulatory costs, and this is means choking off of money to small business, which is the largest generator of jobs in America. And if you wonder why we're in a job, why we have a low labor participation rate, this is one good place to start looking. And of course, there is a lack of diversity in approach to financial intermediation, and so it's a loss of, as we heard this morning, and again from the luncheon address. There's not the kind of competitive approach to what is the best way to solve these problems. We have convergence on how to deal with them, and I think that is a big loss. And of course, for the regulator, it offers enormous opportunities for blackmail and for rent seeking by the biggest players in the game, who hire the best lobbyists and who have the fanciest offices on Wall Street. I think that to turn this around, judges will have to expand the efforts that Jeffrey's already talked about. They have to get more aggressive. I think you see evidence of that. I love the statement of Justice Scalia in one of the cases knocking EPA way back on trying to change the rules of new source review, saying the minimum threshold is not the statutory 250 tons, but we're going to say it's 75,000 tons and move it down as time goes by at our discretion. And he says in his decision, we're not going to sit idly by on the dock and wave goodbye to EPA as it embarks on its voyage of discovery. And that's, I think, one of Nino's better lines. I think what you heard from Reg Brown and from others about what the CFPB has done with auto loans, it's astonishing. If one interest group really did pull out all stops to get exempted, it was the auto dealer distribution network. And of course, they're back in the soup again. And how do they know about disparate impact and racial discrimination on alleged loans? Well, without knowing who gets the loan and who made the loan, well, they went and checked by zip code the last 3 letters of everybody's name, as if that would tell you what ethnic person area you came from. I mean, it's really horrible stuff. But my favorite story, and I'll stop with this, my favorite story is the story of the renovation. Many of you have heard this, but I think it's worth repeating, and I hope you will repeat as much as you can, because it sort of encapsulates what's wrong. The Consumer Bureau, of course, is not funded by the Congress. The Congress has no ability to pass an appropriation rider or to clip its appropriations or to ask it to do anything, because it's paid by the Fed. The Fed has to do this. The Fed's prohibited from intervening itself. And so the agency can do anything it wants to. Even the judicial review is somewhat curtailed, because the legislation orders that the CFPB, with respect to all 18 statutes it is sort of monopolizing now, get the primary deference. And what the FTC thinks about its statutes is now irrelevant. In their renovation, because they can spend what they wanted to spend, they spent more per square foot than it cost to build the Bellagio Hotel in Las Vegas. And when called up, he was called up and was able, they were able to at least question him about this. Cordray, the director, was asked by a congresswoman who paid for this rather lavish renovation, and his answer was, "What does it matter to you?" I'll stop there.
Sounds like Hillary.
On that note, I think I was invited to be the skunk at the party. I originally was going to say I was going to be invited to be the dog at the party in hopes that some people like having dogs at parties. But based on today's luncheon address and the fact that I'm going to sound a note of skepticism about judicial review of these kinds of questions, I think it is better to call me the skunk here. My hope, though, is that I will blast you with this odor so profoundly you have to work at washing yourselves of it and coming to a different conclusion. I'm mindful, too, by invoking this note of skepticism about around this question, that even if we agree that the Congress that wrote Dodd-Frank and designed, and the Republicans who came up with the idea of the CFPB, I didn't misspeak there, this is originally a Republican idea. The question is whether we should be in the business of relitigating this question through our judicial system. And signing that note, as a historian, I'm mindful of the fact that every generation has this debate again and again and again, from the very beginning, of course, when Thomas Jefferson's antipathies for John Marshall and extend them forward to Theodore Roosevelt wanting to have, by popular referendum, the recall of judges who disagreed with him, through his distant cousin and the court-packing plan, and as we heard from Richard Epstein, the great debates in the 1980s about whether conservatism was about using the judiciary offensively or defensively or not at all. So I recognize that. It's almost like the MIT joke where the professors realized that everybody was repeating the same jokes over and over again at faculty meetings, so they decided to number them, and so they'd say 17, and everybody would think for a moment and laugh appropriately. I want to say the number associated with judicial restraint, but hopefully I'll say a few other things that are going to be more topical and blast you with that smell to see if I can convince you. So four very brief points that we can expand on in Q&A. The first would be this question: can Congress speak? Can we have this political moment, the fervor around institution building directed through this political process? Can that be a specific kind of conversation, or must that conversation always continue when the losers of a legislative action just pick up again by continuing the conversation with very similar arguments in a different forum through litigation? So number one, can Congress speak? Number two, a question about justiciability. Absent from the PHH opinion, 110 pages though it is, question of who is the appropriate litigant, not to challenge whether the CFPB acted beyond its statutory authority. That seems pretty obvious. It would be Ambassador Gray's client. But the question that it's just assumed in a footnote, this theory that if you're a regulated entity, you can always bring these big constitutional questions, whether or not the constitutional question resolved in your favor would change the outcome, whether or not you are facing a real case or controversy, or the court can redress this problem, contrary to standing doctrine. Third point about elections having consequences, and then last of all, what I view to be the real constitutional question by judicializing what is an intensively political process. So the first, can Congress speak? It's not the case that the CFPB was sitting on Ralph Nader's shelf, pulling off, waiting for a crisis that couldn't be gone to waste. The battles, the legislative battles in forming the Consumer Financial Protection Bureau were pretty intensive. It looked different when it came out of the House and then got to the Senate. In a terrific account, Bob Kaiser, a journalist who wrote The Act of Congress, History of Dodd-Frank, talks about the ins and outs and how it went back and forth, and thinking hard about institutional design, about having a single director versus a more traditional commission structure, about its funding mechanism, and having these intensive debates. It actually almost makes you proud of America in the sense that these were very substantive debates with people taking different kinds of positions, thinking about problems of how to make rule of law commitments that would bind the future in a way that could be clear to all. There were winners and losers in that debate, as there are in any political process. But what's so fascinating to me is that Congress did have a chance to speak. and the 2008 election that led to the Congress that passed Dodd-Frank was built around this idea that something had happened in a financial crisis, bringing to bear the political process to say not only what happened here and how can we prevent it from happening, but also what happened here and what are the other issues that this brings to mind about how Americans might need to look at a financial system that will treat them differently than the one that came before. And the problem I have with the PHH litigation and many other kinds of litigation around these, the nitty-gritty of institutional design, is it feels very much like that political process redux. And so this leads to the second point about justiciability. Why is it that the CFPB being able to, the director, Richard Cordray, being fireable by cause in the Obama administration would change anything about the way it behaved, including illegally, to its regulated entity? Well, you might say, well, because Obama would recognize that he'd be politically accountable for the PHH enforcement. Does anyone think that the CFPB during the Obama administration, directed by someone that President Obama put in place, doesn't have that link already? It starts to get very speculative in my mind that if the idea is, well, we change that feature, then we get a different outcome. Exactly the kind of speculative argument that would normally be dismissed on jurisdictional grounds in this way, that this just would be non-justiciable. A better argument might be that in a Trump administration with Richard Cordray acting toward PHH and the CFPB acting toward PHH the way that it did. But again, that seems like the better litigation would be one that's structured more like Humphrey's Executor, an antecedent institutional design constitutional case, where Richard Cordray does something that Donald Trump doesn't like. Donald Trump fires him. Richard Cordray says you can't because the statute, and then they litigate it. That would make me much more comfortable than the litigation as it was. As it is, the DC Circuit case says nothing about this issue except in passing in a footnote, something that's only less confusing to me because the Supreme Court in its 2010 case did virtually the same thing in Free Enterprise Fund versus the PCAOB. The question, point number 3, the elections have consequences. And I'm going to have to start speaking with Richard Epstein speed so I can get through this. Elections have consequences. So I had a candidate in the 2016 election that I was rooting on and writing checks trying to support and pointlessly engaging my Facebook friends and trying to convince them of the errors of their ways and the wisdom of mine. And my candidate lost. And I was very disappointed by that loss. But the point is that the other candidate won, and now the time has come that we get to look at what the consequences will be. And newsflash, the CFPB is in real trouble. Bigger newsflash, more trouble in ways that I think would please Ambassador Gray and his client than the DC Circuit opinion that was handed down. Now, I may not like that, but that's the reality. And I think we should embrace that reality, that the CFPB is going to be in for a political fight as a result of this election. And if it had gone the other way, it wouldn't. And I think that is the appropriate locus for this kind of institutional design. If we were talking appointments clause kind of issues, so maybe one of the czars that reign inside a White House gets enforcement authority, that starts to raise constitutional questions that look better for an adjudication than these kinds of nitty-gritty institutional design questions do. And this raises the other question of, are our suspicions about the ideology of technocracy, our certainty that technocrats are in fact just progressives in sheep's clothing, is odd to me when we relax that assumption for judges. And I have to ask Ambassador Gray, when you saw the panel draw that was Brett Kavanaugh and Judge Randolph and Judge Henderson, did you not say a Hail Mary or prayer or rejoice or throw a party? I mean, that is an extraordinarily lucky draw at the DC Circuit for exactly this litigation. The point is it's an echo of a political process that has come before. So my challenge to a Richard Epstein-like argument saying, no, we should use the judiciary different, is it's endogenous to the very political system that you're critiquing. That the same expertise and ideologies that are wrapped up together, form together, CFPB and the Fed and the judiciary. Last point I'll say is that, all related to this, this is the constitutional question that makes me so uncomfortable. That the separation of powers motivation in saying Congress cannot bind the hands of the president because of separation of powers, I get that, that resonates. But when the question then comes to the judiciary to say, and so therefore, a commission structure in this way is appropriate, a funding structure so long as we move in that direction or this direction, and the trade-off between for-cause removability here or there, that starts to look like legislating to me. This isn't an appointments clause question where you're asking, did this follow presidential nomination with Senate confirmation for principal officers of the United States? It sounds like institutional design. And if you read through the brief in PHH, and you read through the briefs that were very well written by Ambassador Gray and the CFPB or the federal government, you see that they are making arguments all about institutional design that sound almost exactly like arguments that we heard in the Dodd-Frank legislative process. And for that sounds to me like the real constitutional question at play.
A lot of great points have already been covered, but just wanted to, I guess, listening to some of the skunk at the party and some of the other comments, I think one thing that's very important in this area is to really try to separate out the constitutional questions from the public policy questions. And I think that there are some real constitutional concerns here that the administrative state has to operate within certain important constitutional boundaries. But there are a number of questions which really are political ones for institutional design interacting within those boundaries. So Jeff and Boyden and Peter talked a lot about the court. So I want to talk a little bit about constitutional accountability in the executive branch and also in Congress. And I hope also in the course of my comments to convey why I think these structural constitutional questions do matter. Going to Peter's point, like, does it really matter whether the head of the CFPB is removable for cause? I think it does. I think it matters in very important practical ways that are not just merely academic. Okay, so talking about executive branch accountability. In my view, the president is really the administrator in chief. The Constitution vests the president with all the executive power, and he's a unitary executive, and that unitariness is an important source of power for the president, but it's also an important form of accountability for what happens in the executive branch. So what is the constitutional mechanism for maintaining accountability and execution? I guess I would argue that it's the removal power. That if there's one sort of minimum of how you maintain executive branch accountability, it's the removal power. And I've argued elsewhere that it's really both necessary, but it's also sufficient. So if the president can fire his subordinates, he can direct them, and he can control their actions, and that's what's constitutionally required. And if that's the case, then of course you can't have agency independence, right? You can't have agencies that are now independent somehow of the president because, well, that doesn't quite work. And so maybe that sounds in some ways like a kind of radical notion, but I think it's actually an idea that follows from certain widespread beliefs that we have, even not just on the George Mason faculty. And that's, when independent agencies, what they're doing when they regulate or they bring enforcement actions, they operate in a way very much like executive branch agencies, right? They're doing the same thing. And as a legal matter, although the court disagrees about independent agencies, there's widespread agreement that all of these agencies are part of the executive branch. So you can see in the Free Enterprise Fund case, which was decided a few years ago, the court said it was unconstitutional to have 2 layers of independence over the PCAOB. And it was a 5-4 decision, but Chief Justice Roberts, writing for the majority, and Justice Breyer, writing for the dissent, all talked about these entities as though they were part of the executive branch and they were exercising the executive power. That was something they agreed about, even though they disagreed about removal. And I think that you can see that in most of the separation of powers cases in this area. The modern cases all recognize these entities, although they're somehow independent, are part of the executive branch. But then I think that's where the logic breaks down, right? Once you recognize that these are part of the executive branch, as of course they are, because where else could they really be, then they have to be under the control of the president. And that brings us, I guess, to the PHH case, which has already been discussed. And so, probably most of you are familiar with that. But one of the things I thought was interesting about Judge Kavanaugh's opinion there is that he does blend functional arguments with formal arguments. So I agree with Peter that when, he's discussing, well, when you can uphold maybe something like this if there's a multi-member commission, that starts to look kind of functionalist, right? Like, how do we put together the pieces to make a constitutional agency? Now, I think in fairness to Judge Kavanaugh, some of that is because, he's on the DC Circuit and not the Supreme Court, so he has to work with the precedents like Humphrey's executor and explain how those fit with his decision. But, so those arguments I think are very functionalist. But then his remedy, of course, is very formal, right? He says the remedy to this problem is we sever the for-cause removal restriction. So now, the director of the CFPB is subject to removal by the president, and then, of course, in theory, it's then accountable to him as well. I wanted to make a point about this, which I think it's unsurprising that in a case where the constitutional challenge was successful, there was a very formal remedy imposed. Because if you look at the cases, whenever the Supreme Court talks about these issues in functionalist ways, the constitutional challenge fails. Right? So the court will never invalidate an agency action or an agency structure on functionalist grounds. So just to give a couple of examples, in Morrison v. Olson, the court infamously upholds the Independent Counsel Act. And part of the reasoning there is, well, how much of an intrusion on the executive power is too much? It's really the question that the majority asks. And they're unwilling to answer that question, right? They're unwilling to say that a certain, that the independent counsel goes too far. Once that question is how far is too far, I think the court's just not going to answer it. And of course, in Morrison v. Olson, Justice Scalia wrote his very famous dissent, applying a much more formal argument about why the independent counsel was in fact unconstitutional. And I think that's an argument that most people now believe is correct. And you can see in other cases where the formalist arguments have prevailed, right? So in INS versus Chadha, the court invalidates the one-house veto on very formal grounds. In the PHH case itself, the formal arguments and, the free enterprise fund case. So I think one lesson to take from that is if you're challenging on constitutional grounds agency structures or agency actions, I think it's important to sort of pinpoint the precise constitutional infirmity and work from there, right? Because you're not going to prevail on a kind of all things considered functional argument. We're not likely to prevail, I think. I think the formalism in these cases also helps to separate out the constitutional questions from the political questions. So if the removal power is really the hard backstop of executive power, then we can have agencies that are accountable to the president, right? And that meets the constitutional standard. And then all these other questions, like do we have a multi-member board? Is it bipartisan? Like how do we fund it? All of these different features. I mean, there's some other limits on those features, but most of those questions are, I think, I agree with Peter, questions of design, right? To be worked out by Congress based on what they want the agency to do and how they want the agency to do it. But with respect to removal, I do think that this is an area in which there's some important practical consequences. So, of course, Director Cordray was appointed by President Obama, and we can assume that the administration and the agency share certain values and goals. And so maybe there's I'm sure interaction, as you say, between those two entities, as there often is with the so-called independent agencies. But there is a lack of accountability. I mean, if you do a Google search of President Obama speaking about the CFPB, you find almost nothing, right? So the CFPB has been criticized for taking a number of egregious actions, acting outside of its authority, violating due process, collecting massive amounts of credit card personal information without taking adequate privacy measures, right? It's subject to all of these critiques. And yet the president hasn't had to answer for any of those, right? He hasn't had to explain why he supports those policies publicly. And, I think it's not crazy to think that those policies might be different if, the White House press secretary, the press secretary had to get up and explain that and defend that, right? I think it's hard to know exactly how the policies would be different, but I think it's hard to believe that they wouldn't, in fact, be different. And so the presidential control, I wouldn't say that it gets perfect administration in any way, but it does get a certain important kind of constitutional accountability. And I think that that type of accountability will have practical consequences as well. Okay, so just a few words about constitutional accountability in Congress. Now, I think the non-delegation principle is a very important one. Just as the Constitution vests the executive power in the president, it vests all legislative power in Congress. And of course, I think it's widely understood that that contains some kind of non-delegation principle, right? You can't delegate the lawmaking power, whatever that precisely means. And there's a lot of disagreement about what exactly constitutes lawmaking power versus execution. But that line has always been maintained by the courts and I think by most commentators as well. That's, of course, a very theoretical line. In practice, what we see is Congress constantly delegates very open-ended authority to agencies and giving agencies a tremendous amount of discretion to essentially, to what all practical effects is making law. And the courts don't enforce the non-delegation doctrine. Perhaps they could do this a little more robustly. But this is an area I don't think we can rely on the courts to really set the lines, right? They're not going to be able to police all the delegations that arise. What you really need is for Congress to reclaim its policymaking power. And it's a theme we've heard in other panels as well. And maybe this is the time, right? Maybe now there will be some bipartisan support for having a more vigorous Congress, right? Republicans will still remember what they consider to be the excesses of the Obama administration, and Democrats anticipating what they might fear with the new incoming administration. Because I do believe that the marginalization of Congress, pushing sort of Congress off to the side is harmful to our system of government. Agency policymaking is less transparent, it's less accountable, provides greater scope for exceptions and waivers and special interests to get what they want through the process. And the Constitution really vests the lawmaking power in Congress for a number of important reasons. We don't have really time to get into those here, but the core institution of a Republican form of government is the legislature. And if the legislature is not working, then a very fundamental piece of our structural foundation is not working. So, I think all of the three branches have a role to play in maintaining more constitutionally accountable government, and maybe we can talk some more about those solutions in the question and answer period. So,
Terrific.
Thank you.
Thanks. So I suppose I might just kick this off by returning to a point that Boyden alluded to in his Bellagio example, which is the attitude of an agency that has access to essentially self-financing that's funded outside the ordinary appropriations process. I think many view this as a piece of the constitutional infirmity or worry raised by the CFPB. I can tell you that it certainly is the focal point of congressional critics' ire in thinking about the CFPB. But in the PHH case, I think maybe I wasn't alone in being surprised that it didn't figure prominently. Judge Kavanaugh described CFPB's exemption from the ordinary appropriations process as, at most, extra icing on the unconstitutional cake already frosted. So I suppose that raised two related questions. One, should that aspect of CFPB's design have featured more prominently in the DC Circuit's analysis? And then as a practical matter, how far does that concern go? Does it reach the FDIC, the Fed, other prudential and financial regulators that are funded outside the appropriations process, and what are the implications? Maybe start with Peter, who I know has studied the Fed more than anyone else in this room, that's for sure.
It's very important to recognize that the ultimate institutional structure that the CFPB took is closely tethered to its funding structure. So the word bureau here wasn't chosen at random. It was seen to be a bureau of the Fed, and indeed the statutory authority it inherited, although a consolidation of multiple agencies, bailiwicks, is primarily the Fed. And so the idea is we're going to have a dedicated, more accountable sub-bureau of the Federal Reserve, located within the Federal Reserve statutorily, not architecturally, much of the CFPB's chagrin. If you've seen the Palace of Central Banking on Constitution Avenue and compare it to the Soviet-style architecture of the CFPB, you can see that they won that, they lost that lottery. But that's the entire idea. So I think that that you cannot say the CFPB is unconstitutionally funded. without first saying that the Fed is unconstitutionally funded. And the Fed's funding is both statutory and extra statutory. It's statutory in the sense that in its original conception, continuing today, it charges for services that it provides, including providing master accounts, supervising the payment system, doing other things. But that only covers about 25% of its funding. The rest of it is through seigniorage. It's through the operation of monetary policy and the income generated from the purchase and sale of those assets. That's the funding process for the entire Federal Reserve System, which includes a bureau called the CFPB. Now, there are people who have said that that is unconstitutional. Wright Patman called the Fed, constitutionally speaking, a pretty queer duck. And in part, he was talking about this funding structure. But I think if you take that away from the Fed, then you have taken away the experiment of doing time-consistent monetary policy, by which I mean the idea that you can do monetary policy that is not buffeted by the day-to-day of electoral politics. And again, some people would say that is exactly the right thing. I would say it isn't, but I think that you can't simply say the CFPB is unconstitutionally funded, but the Fed is constitutionally funded without doing some rhetorical acrobatics that I don't think could be sustained.
Boyden, what about that?
Don't know really where to start, but let's take the funding to start with. The Fed really serves two functions, which aren't necessarily related. In fact, they probably should be separated. One is monetary policy, which I think is actually committed to Congress to control, and so if Congress wanted to have it off budget, that's, maybe Congress's business. The other side, of course, is the regulatory side, which is where the Bureau belongs, although the Fed is barred from having anything to say to the CFPB. But the regulatory side, I'm not sure should be off budget. I think it should be part of the budget. I think you should divide the Fed into two parts, conceptually anyway, if not actually, and treat the two the same. And I'll give you an example. I don't want to take up too much time telling a personal example, but at one point when I was in the White House, Volcker came to have lunch. He wanted to come have lunch because he was going down to give a speech at Wake Forest in this little town of Winston-Salem where I grew up. And he knew that I come from Winston-Salem, so he wanted to know what there was about it. And his wife wanted to go because she was a Moravian, is a Moravian. And there were two Moravian settlements in the United States, one Bethlehem, Pennsylvania, the other Salem, which later merged with Winston. And so she was very curious to go down, and he's talking about various things, and I told him that my family had been involved with Wachovia Bank, and so his assistant, he pulls out this big spreadsheet, and he goes down, Wachovia, no foreign loans, he says. Wachovia hasn't made any foreign loans to foreign governments. And I said, well, I didn't know that. Well, we're going to take care of that, and within the week, Wachovia was making foreign loans to foreign governments. Anyway, I don't know that shouldn't be funded by the Congress. And by the way, the funding operates in such a way that Dick Fisher, who just retired as head of the Dallas Fed, told me that they had no pay scales, so they were stealing all the best economists from the Federal Reserve System because they could pay them more. So that's another sort of little glitch in the fact that just the Bureau of the Fed. You talk about the political aspects of this. I'm told that, and I haven't actually sat down and read it carefully, but I'm told that Finance Committee Chairman's bill was inspired much by the litigation as by anything else. So I think that sometimes litigation does serve a multiple purpose of involving the judiciary as well as the Congress itself. And then to get back to a point that NEOMI was making, the non-delegation doctrine is, I think, an important feature here, and the law is that if you have a non-delegation, a serious non-delegation issue, it's the courts that decide what the law is, not a deferent situation to an agency interpretation. And I think that's an important factor to remember. I hope I answered your question.
Great. Yeah. So a number of the panelists have referred to changing to deference, and I think it's fair to describe growing skepticism of Chevron deference. One original rationale for Chevron deference is the idea that if there are gaps in statutory schemes, they ought to be filled at least by politically accountable agencies rather than unelected judges. I think it's fair to say that rationale grows a little bit more attenuated when you're dealing with independent agencies operating in the arena of financial regulation. Is there a case to be made that Chevron deference should be applied at least differently when dealing with review of statutory interpretations promulgated by independent agencies?
If you're asking me, I really don't think so. And part of that is because I was brought up from the early days in 1981, beginning when we first did the first executive order on regulation and exempted the independent agencies, not because it was constitutionally required, but because it was politically probably necessary. And in those days, the independent agencies, the FCC, and the financial agencies didn't have anywhere near the same power they have today. So I don't really acknowledge the constitutional difference to start with. And I don't think there are any consequences that flow that make them any different than so-called executive branch agencies. I'd like to take this opportunity to say one other thing. We did get, you're right, when I saw the panel, when we all saw the panel, we said, whoa, how can this be? This is a 1 in a million coin toss. But I do have to point out, sort of another parochial point, that there was a dissent in the case, and that was from Judge Henderson, who was
concurrence, right?
Well, it was concurrence dissent. It's hard to know exactly. Disagreement.
Well, she rejected the constitutional analysis.
She rejected, all right, well, from the constitutional point of view,
Yeah,
she rejects the constitutional argument, invokes the doctrine of constitutional avoidance, and that may very well be what holds in the D.C. Circuit. Is footnote 16, by the way, that talks about the icing on the baked cake. For those of you who want to read this footnote without having to read all 120 pages of the opinion. And just one final point, Judge Henderson is from North Carolina.
Naomi,
Yeah, Brian, if I could, I agree with Boyden. I sort of also reject the distinction in terms of, from the executive branch perspective, how independent and so-called executive branch agencies need to be treated. But, that view is becoming more widespread. So, I'm on the American Bar Association Administrative Law Council, and we issued a report to the president-elect in which one of the recommendations was bring the independent agencies under centralized review. Now, the ABA Ad Law Council is not, kind of some fringe group, right? It's made up of, scholars and practitioners who are quite mainstream, probably more left-leaning or progressive, and that was one of the recommendations that was adopted, and it was actually a recommendation that the ABA adopted, I think, even in 1990. So, I think that there is some recognition that this is not, there's a lot of consensus, I think, around that. And I guess another point just about deference, which is, I think it's very hard to separate out the deference questions from the non-delegation question. So if Congress continues to enact really open-ended statutes, well, then there's no law. And so what are the courts supposed to implement if they're not deferring? And I think that's a real problem. I'm also skeptical of the deference doctrines, but in part the deference doctrines arise out of the fact that these statutes don't have a lot of law. And then, well, where do we get the law from? And maybe the right answer is, well, then nobody has the authority. If we can't figure out what the statute requires, the agency just lacks authority. That could be one answer. But I think it's those two questions are so closely connected.
Why don't we open it up to audience questions? Professor Epstein.
I just want to pick up on the very last sentence, because when you talk about deference and non-delegation, I agree with you that they go together. But why is not the appropriate remedy under these cases to say, I can't figure out what you need to, you can't tell me what it is, and that we have a two-part test. First, is this thing unintelligible, to which the answer may well be yes. And then second, I'd be willing to let unintelligible statutes for public interest, convenience, and necessity if I couldn't find any narrower words that would be able to help the field to do it in a sensible way. I'm just curious what all of you think about that. Some kind of combination of that sort in order to sort of deter the problem instead of just throwing up your hands and doing exactly what you've always done in this case, which is to allow bad laws to create bad administrative actions.
So you're saying if there could be some cases where there's not an intelligible principle.
And just strike the thing down.
And just strike the thing down. Well, maybe that's what the
Avoid
courts should do.
vagueness, and then we can do this on a loitering statute. And I know what law means. If you give me 1,000 people on the street corner, I can get 999 of them the same way that you would get them. Right? So that turns out to be hopelessly vague, with a reliability of about 99 plus. These things, there would never be anything close to consensus on it. And so why does not one become a little bit more aggressive in order to control administrators of executives who have a lot more discretion and control than Congress?
I think the courts could be more aggressive. I just don't believe that the courts can do all the work. You know, I'm
We're
sorry.
trying to fit for the next generation. We're running a youth movement.
You're off the record now.
Yeah. I mean, you know, I would support more robust enforcement of the non-delegation doctrine. I just don't think the courts can do all the work, right? So you have to have a Congress that steps up and does its job. So the courts could be more active, but they can't fix the problem on their own.
And my view on,
go ahead.
oh, sorry. So on deference, I think that the shelf life on these debates about deference are approximately 1 minute after 12 o'clock on January 20th of 2017, in part because the Chevron deference is so easy for motivated judges to look beyond. There's just, you look at it, it's like, I don't think this is a reasonable interpretation, so I don't have to get to the question of deference. And on my year as a law clerk on the DC circuit, it became kind of this inside joke. I'm not betraying any confidences when I say there are lots and lots and lots of ways to look at a statute, and judges want to defer. It's a little bit like just saying, yeah, okay, I'm not so motivated by the wrongfulness of this that it's become an issue. And I think once we're deferring to agencies controlled by appointments of Republicans with Republican Congress, and especially with Democratic Congress, then this gets irretrievably wrapped up in presidential politics as opposed to deeper principles of administrative law.
Are we, so I guess a logical question then is, are we likely to see the skepticism of Chevron that we've seen, I think it's fair to say, from more conservative quarters recede as judicial challenges, well, perhaps this is wishful thinking, but as we see judicial challenges to deregulatory actions? Or will the principled opposition to Chevron deference survive?
People like Naomi Rao will continue to have principled objections, right? That continues. It's just not a core part of the governing coalition, right? And I will say, folks on my team are, if Democrats win Congress, is virtually inevitable during a Republican administration following historical trends, then all of a sudden you're going to see all kinds of arguments about how courts aren't doing their job checking an aggressive executive, because that's what presidential politics is about, and Chevron just becomes a football that you kick back and forth on this. And the same thing, not that there aren't principled folks on both sides, it's just that the core strategic interest within either coalition is going to be checking ideological opponents' power as those powers shift in and beyond administrations.
But I would say, Peter, that it's not just change of administration, it's not just sort of fluctuating back and forth. There's been a systemic secular decline in the role of courts over the past 100 years in terms of their willingness to review administrative action. And I think that's a bigger tectonic event than, obviously, the political changes back and forth will always be there, but the broader change in how administration is conducted. That's been true in Democratic administrations, Republican administrations, and it's going to continue to be the case. So I think we also should look at it in the broader historical framework, which is what you do. So.
Right.
If I could just make as a political football for the party, I'm not sure. I mean, Congress needs to have a big boot in the butt, and I think if the courts were to throw out a couple of statutes, not having done so since 1937 or 8 or whenever, that would help wake Congress up, because I do think Congress, I don't, maybe should be careful what I say in front of top staffer, but Congress needs to be a little bit more attentive. And if you were to ask people who are just now working in Washington, maybe for the last 5 years, what an amendment to the third degree is, most of them would look at you, what in the hell are you talking about? Indeed, many of them probably don't even know what a markup session is. So we've lost a lot of the legislative process of whoever's in control, which is where so many of these issues used to get used to get really fought out in the most tense circumstances. And that's a very healthy thing in a democracy, which has been lost.
Additional questions?
I don't know whether you all are being genteel and polite because you're on the Virginia side of the river or what, but I think you're radically understating the commitment to principle following noon January 20th. You may have the count right with NEOMI, 1. But, I mean, we've already seen, I'll pick on my so-called party, if you want to taint me with being a Republican. I'm a Republican because they're wrong less. They're completely outcome-based, no more or less than the Democrats. You will not see great enthusiasm for the line of assault that we took against much of the executive overreach. It's now going to be kind of our executive overreach, if you will. But we already have that evidence. I mean, when Obamacare, the month before Obamacare was decided, it had already been argued, just because I was the closest attorney general who was in the case, involved in the matter, I would come and explain to congressmen every so often what was going on. And since I was up there, this was the time, and you all won't remember necessarily, but Republicans were floating medical malpractice reform. Sounds great, right? We all love medical malpractice reform. And as part of this reform, they were going to tell state judges how much they could award in particular types of cases. Really an extraordinary form of overreach. And since I was there anyway and hadn't ticked anybody off yet, I brought this subject up and it was discussed, mostly medical-focused congressmen. And I said, you know, if you all were ever to actually successfully get this, we'd sue you faster than we sued the president over Obamacare, and we'd kick your butt. It'd be easy. And every single one of them got instantly furious. And maybe I'm not the most diplomatic presenter in the world, but I mean, they dropped federalism like that. And if you're paying attention to any of the left-leaning opinion right now, they have rediscovered federalism already. It's already happened. They're already writing about it. You know, you see Senator Coons from Delaware regretting getting rid of the filibuster requirement for nominations and so forth. Gosh, we really made a mistake there. Oh, God, we could hardly foresee that speech coming. And so the coin is just flipped. It is still going to be up to intellectually honest, idealistic people who believe in restrained government and the rule of law to keep suing, regardless of who's in charge. Because until enough of them take enough beating and their ox is gored, you're not going to get structural changes to start to limit this sort of abuse. I'm just convinced of it.
And that's the reason why I'm not sure we can put that much hope that the Congress is going to solve this problem, because it's composed of politicians, and even if you're a Republican politician, you still want to have influence and control. I'm not sure that a Republican Congress is going to be as deregulatory as people may anticipate.
So I suppose, I mean, raise the question, so where should the solutions to some of the ills we've described come from over the next, say, 4 years? Are critics of the administrative state likely to be pursuing solutions through the political process rather than through litigation? What do you foresee?
So Congress has the worst approval rating of anything, but when I hear people railing against Dodd-Frank or in litigation, or saying, you know, this is ridiculous, and I say, well, just pass a different statute, right? And they say, oh, that's ridiculous. You see how dysfunctional Congress is. And I think, but I completely agree with Naomi. That's the government we have. That is the constitutional structure. You cannot hold up the Constitution with one hand while saying Congress is useless and statutes deserve no respect with the other, because they're one and the same. Indeed, Congress is one of the most important innovations of a bicameral Congress with veto override authority is one of the most important constitutional innovations. So the things that you don't like, I agree with Attorney General Cuccinelli that this is incredibly important to think about from a lot of different ways. I think the number of principled folks who think along these lines is large. This is how political party realignments occur, and they occur sometimes formally, sometimes informally. It happens constantly. But I'd also say we cannot give up hope in the idea that you see change happening through Congress, because that is giving up hope in our form of government.
I think that the major instrument for change is not going to be the Congress, it's not going to be the courts, it's going to be public opinion and the sense that people have that the administrative state has gotten too strong. And that's part of the reason for the election result, I think, that we see. So, what, Richard? No, you see, Richard's saying we're out of time. But, you know, we really should realize that the public opinion is as important as any of the instruments of government that we've been talking about.
And Professor Epstein, as usual, is right. We are, I'm afraid, out of time. And want to thank our fine panel for this discussion, and I think we'll reconvene at 2:30.